There you go. So, Ms. Pavarotti, your favorite on the semester playlist. Make sure you have a course evaluation, but do not fill it out until I leave the room, and I'm going to leave a lot of time for you to thoughtfully do the course evaluation, because I take them very seriously and try to fix problems and respond to student needs. I will never understand the minds of undergraduates. This is a self-inflicted wound. I thought I'd maybe get 5 or 6 extra credit papers. They're down here, don't put them down there. Don't put them down there. If you put your extra credit paper down there, it will disappear into the black hole, because those are papers that haven't been picked up from our last go-around. Here are the extra credit ones. On the course evaluations, I need a volunteer to wait until everybody has finished them. There'll be plenty of time before the class hour is up. And take them over to 231 Evans. Can somebody do that? Thank you. Here's the envelope. So is this Kimberly? Yeah. When you're finished with your course evaluation, give it to Kimberly at the end of class. If you didn't get one, there's more up here. No more extra credit after today. That's done. The paper is it, and no more online participation credit. You feel free, of course, to ask questions in the general discussion part of forums, or to engage your fellow students in whatever conversation you want to have. But you won't get extra credit for anything that's posted after today, after a couple hours ago. All right. Child pornography. What a way to win. Back in the 1980s, the Supreme Court decided New York versus Ferber, a case that dealt with child pornography, which is probably the simplest to define of any of the restrictions on free speech. It's simply pictures, images of children doing something sexual. And it includes lewd poses and stuff, not just actual intercourse or some other sexual act. But the issue that was decided in the Ferber case in the early 80s was whether the images had to be obscene in order for governments, in that case it was a state government, New York, or the federal government. Both states and federal government have prohibitions on child pornography, and the prohibitions are really strict in the sense that it is a crime, everywhere that I know about, to possess images of child pornography, not simply to sell them or distribute them, but to have them is a crime. And the question before the court in Ferber was, do the images have to be obscene in order to be prohibitable? And the court answered that no, reasoning that the very production of the pictures was child abuse. You can't make pictures of children doing sexual acts without abusing children. It's child abuse. The very production is a crime, and therefore the court reasoned to eradicate the market for these things, to eradicate the incentive to make these pictures. They need not be obscene. Minors, of course, can't legally consent to anything, so we're talking about sexual acts by unconsenting minors, and pictures of that are child pornography. Then came the digital age, and Congress, as we've seen, wanted to do something about the traffic in child pornography on the internet. And so they, that's the American way, passed a law, the Child Pornography Prevention Act of 1996, that amended the federal child pornography law to make it a crime to create or possess any image that appears to be a minor engaged in a sexual act. And that raised the question of what appears to be a minor. It might be, for example, a very young-looking adult, somebody who's 18 or 19 who looks very young. He or she might appear to be a minor. There we go. And the constitutionality of the law was challenged, of course, in this case by a group of people in the sex trade who don't deal in obscenity or child pornography, but who feared that they might be prosecuted for whatever they published and sold. And when the constitutionality of the law was challenged, the government came in and said, well, what we meant by appears to be, they're telling the courts this, is the computer-generated images, now possible, that are virtually indistinguishable, the government argued, from pictures of real minors. And I don't know, do you, whether it's possible to make an image, a picture, with no human involvement at all, entirely digitally, that is virtually indistinguishable from a picture of a real person? Where's my case? Yes? You wouldn't be able to tell. You couldn't even guess that this is a... Well, what are they doing in this video? Really? Huh. How recently do you think this was made? Yeah. So 1996, we're talking in the same, virtually in the same.
I would think that, like, for me, it seems like I feel all this, like, computer, that kind of requires a little education that no one gets on that point. So I think that for some people, it really could be frustrating to people, but at the same time, it kind of reads like you need a very professional artist to be able to render something that realistic, and I feel like that doesn't work for me.
Let's see if these are virtually indistinguishable from real people. The guy on the left, you remember who that is, right? Or you've heard about it, you've seen pictures of him. That is the real Richard Nixon. Elvis is not the real Elvis, is he? And I have never shaken hands with Richard Nixon, I promise. But that was done by a friend of mine who believes, like Case, that it is now possible to make images that are virtually indistinguishable from real people, although I don't think it was at the time they passed this law. And the government argued that even images that are created without using any children at all, that appear to be children doing sexual acts, should be prohibited, and it should be permitted under the First Amendment to outlaw these images for two reasons. One, these images may whet the appetite of pedophiles. They may get turned on by these images and say to themselves, I want that. I want to do that. Whet the appetite to go out and find some kid to abuse. And second, the virtually indistinguishable images might be used as a seduction tool by pedophiles. Show the kid, look, doesn't this look like fun? We should try other kids do it. We should do it. And that changed the rationale that the government has used up to that point to justify prohibiting child pornography. Instead of the rationale being the mere production of these images is child abuse. Here you got no children involved in the process at all. And the rationale is, well, whetting the appetite of pedophiles or creating a potential seduction tool is justification enough. Well, the case went to the Supreme Court. The law was upheld in 4 different circuit courts of appeals in criminal cases for prosecutions for possessing images that appeared to be children having sex. And then in the Ninth Circuit, this group of sex trade publishers and activists, the Free Speech Coalition, always nice to have a euphemism out in front, the Free Speech Coalition succeeded in the Ninth Circuit in having the law declared unconstitutional. So the government took the case to the Supreme Court, and the court decided the case in 2002. This was a really tough case. I mean, what judge, what thoughtful person would want to come out in favor of child pornography? It's so toxic. And yet the Supreme Court, led by Justice Anthony Kennedy, decided that the law was unconstitutional, a violation of the First Amendment. And one of the issues that the court had to deal with is how to construe this law. It says, appears to be, and that, as the court pointed out, takes in young-looking adult actors and actresses and so on. It also takes in paintings, Renaissance paintings and various images, scenes from classical mythology and so on. And there's no basis, Justice Kennedy said, for narrowing the scope of the law the way the government would have it read, that is, to these computer-generated, virtually indistinguishable images. That isn't the law that Congress wrote. The government stuck with what Congress wrote, which was the appears to be language. And Justice Kennedy pointed out that really great movies, for example, like Traffic and American Beauty and Lolita, based on a Nabokov novel, all involved very young-looking adults who were acting in what appeared to be sexual scenes. And those movies would be prohibited, punishable, under the language of the law. And then Justice Kennedy looked at what was missing in this law, and principally what was missing was the third part of the obscenity test, whether the material lacks serious artistic, literary, scientific, or political value. That was not a requirement. And so, as in the case of indecency, you're talking about outlawing material that may well have serious literary, artistic, and other societal value. And Justice Kennedy points out that even one sex scene in an otherwise great movie would condemn the movie as a violation of the law. Then he acknowledged, of course, that sexual abuse of a child is a most serious crime and an act repugnant to the moral instincts of a decent people. But the prospect of crime, the government's theory about whetting the appetite of pedophiles, does not itself justify laws that suppress protected speech. And though this is a kind of speech that offends our sensibilities, that doesn't mean that it can be prohibited. The problem with the law is that what's being outlawed are pictures that do not involve children at all. And as for the government's argument that these pictures can lead to child abuse, whetting the appetite used as a seduction tool, he said that the causal link between seeing the pictures and abusing the child is unproven. And there is some social science evidence to that effect, as there is with obscenity and rape, for example, that seeing obscene pictures has not been shown to cause rape. Similarly, seeing pictures of kids in sexual acts does not cause sexual abuse. It's hard to do studies in this area because there's no exception in the child pornography laws for research, for example. University professors who would like to research this subject do not dare acquire a child pornography image. That would be a crime all by itself. And the principle that Kennedy reinforced in this child pornography case is one that we've seen before. The tendency of speech to encourage lawful acts is not a sufficient reason for banning it, citing Brandenburg. Could have cited Hersig versus Hustler. Could have cited the American Booksellers case. Planting bad ideas cannot be prohibited. And since there was no showing of an actual causal link between having child pornography and child abuse, the government's proposed rationale failed. Then Justice Kennedy concluded that the law was invalid because it was overbroad. Sort of like the other internet cases, Reno and the Copa cases. It forbade speech that was protected. and was therefore unconstitutional. Images that were not obscene and that do not use real children in their production, that's protected speech. Justice O'Connor concurred in part. She would have upheld the computer-generated, virtually indistinguishable kind of images, but she agreed that the youthful-looking adult films, for example, were protected and couldn't be prescribed. The court was invited to, but didn't take the invitation, declared the law unconstitutional because it was vague and didn't give fair notice to anyone of what exactly it prohibited. But the court decided it didn't need to go there, and the First Amendment conclusion was sufficient. Julia. If they what? The result would be the same. The law would be unconstitutional. But the theory of vagueness is it's a due process notion. It's not a First Amendment notion. And if any criminal law doesn't give people fair notice of what's prohibited, if they have to guess, reasonable people have to guess at what's prohibited, and if they guess wrong, they go to jail, it's going to be declared unconstitutionally vague. That happens every once in a while. Go on. Curfew laws? Yeah.
So we have laws like that protect children. So aren't the images that include like people who are over 18 and those who are young? Why is there not a federal law that protects children at that level as well? Like I know that that's kind of gray area where like someone's 19 and those who are young, like someone's supposedly like 15 or 16, like would that not?
Why would the 18 or 19-year-old who looks young need protection?
Yeah, that's what I'm saying. It might not be like in the other cases, it should be like there's some sort of law that could be applied, like similar to like the reason behind why children need to be at home by 10 p.m. to apply to like why images like showing children have sex.
So your curfew law would say that anybody under 18 has to be in by 10, and anybody who appears to be under 18 has to be in.
The reason behind why we have curfew laws, like I'm not entirely sure, but there's some sort of idea that children should be out late at night
Right.
for whatever reason, right? So like whatever that logic is, can it be applied to this and to say that children don't be protected by more like a material that they can see like they're being screwed.
I don't know if somebody can help me out on this. I don't know what the answer to that is. Nicole? Okay, let's change. I have nothing to contribute on that, so it's obvious that I'm empty. Let me ask you about the minority TV, I mean not the minority TV, the AID versus the Alliance results. Those of you who did, I can't believe I got all this. Those of you who did papers on it can help me out. How many of you decided that the law was unconstitutional? Camille, were you, oh, that's not good. Were you late putting up your hand? All right, 27 then. And how many of you decided that it was constitutional? Only 7, huh? There's a lot more papers in here than that. So some of you decided something else? Who decided something else? I mean, there was one other option, right? What's the other option that the court could do? What? Right. I mean, we only got 8 justices here, right? Because Justice Kagan recused herself, probably because she worked on the case when she was Solicitor General. So we only got 8 justices, and if they split 4-4, it's a no-decision case, and there's no opinion written. The court would simply, may well do this, issue an order saying the judgment of the Second Circuit is affirmed by an equally divided court. End of story. So that the Second Circuit decision stands. So people thought it was unconstitutional because of what? What was the gist of the flaw in this law? Anybody who voted to say it's unconstitutional can answer that. Okay.
They addressed the kind of organization they were this basically, I went to a viewpoint argument, and although Breyer kind of like tried to knock that down there in the whole argument, just the figure, it was overbreadth.
Does overbreadth fit this kind of a law? I mean, normally, where we've encountered overbreadth as a constitutional flaw, it's because the law prohibits speech, restricts speech in some way, in an overbroad way, that, as in the child pornography case, prohibits speech that is protected. It's overbroad. Maybe if it were really narrowly targeted, like something the government could prohibit it, that would be fine, but it goes beyond that. Well, here, the government isn't, is the government restricting speech? No?
Yeah, it is.
Wait, Alex, say this. Oh, okay, hang on for a second, yeah?
I thought that it was because they also alluded to the fact that AOC couldn't enter into dialogues about the possibilities of the pros and cons of legalizing